The laws, there are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Hello. Good afternoon to all of you. It's good afternoon from the UK and wherever you are watching us from all over the globe. Greetings to you. I'm so excited to come your way today on Hanging Out BWF Solicitors. I hope you're all keeping well. My name is Vicky Newton, and today we're going to delve into a new topic, as I always promise. And today's topic is, can I apply for leave to remain having been on the 10-year route, then switched to the 5-year route? So that is what we are going to discuss today. But before I introduce our lawyer, solicitor, and also partner of BWF Solicitors, I would also, ask you to please share this program. Anytime we have this program, I get so many phone call messages, appreciating this program impacting their lives. And a lot of people who watch us every time do share it to all their platform and contacts. And through that, people, get answers to all their queries in regards to immigration, contacting Lawyer Eunice to help them with their application. So I will entreat you to please share this program on all your platforms. If you want to contribute to this program by text message, phone call, please do so on our Facebook page at BWF Solicitors. On YouTube is also BWF Solicitors. The phone line is 0744-8619711. If you want to send us a WhatsApp, you can, of course, do so on the same number. Once again, you are welcome to Hanging Out with BWF Solicitors. Lawyer Eunice Achampon, you are welcome to today's program.
Hello, Vicky. I hope you're doing well.
Yeah, I'm doing very, very, very well. I think this Saturday you are looking more refreshed.
Oh, that's good.
More refreshed. But I know you were so busy with work, especially because of the deadline on the 4th of October. Am I right? For applications?
Yes, I know.
Yeah, you've been very busy. But for some reason, I don't know what you've been doing, but you look so refreshed.
It's because, of course,
you don't look tired.
We definitely have to rest at some point. We can't always work. But it's good that at least most people have been able to gather that the fees are increasing, but they know that obviously we are here to help them
Yeah.
submit their applications and the rest of it when the time is needed. So yes, it's good to come back on our show once again this last Saturday of the month. Can
Yes.
you believe it? September is already
It's
gone, and
already gone. Yeah. So
yeah,
we have
yeah.
to we have to prepare for Christmas.
I know. What we have, what, another 11 or 12 weeks before Christmas.
Yeah.
Not very far. Not very far.
Yeah.
Yeah.
Yeah. Laura Eunice, if you wouldn't mind me mentioning this on today's program, just paying our respect, to the girl who was stabbed. And we are all based in Croydon,
Mm, mm,
and
mm.
just want to wish the family all our condolences, our
Yeah.
prayers. Are with them at this difficult time. I think the lady's name is Elian Andam,
Yeah.
and her parents are Ghanaian, so she's a Ghanaian as well.
Mm,
So this has really shaken the whole country, but especially the Ghanaian community in the UK.
mm,
So briefly, I just want to wish them from us on hanging out with
mm,
BWF solicitors. We send them our condolences. But it's so sad. Laura Eunice, you always
mm,
use that route to the station, to
mm.
the train station to get to work, isn't it?
Yeah. And is actually a former church member's daughter. So
Really?
I, when I found out, I was like taken aback because um it's it's been a tough road for the family in the first place, and even to have her was a miracle.
Oh,
um
no.
so when I heard of it and I heard the family, and I said, oh no, this can't be. I cannot imagine the shock waves that went through the mother and father's body when they
Yeah,
heard the news.
yeah,
um when you've literally gone through so much pain to obviously have your child, and then for your child to be taken away with such great injustice, and you don't have any words or explanation to give, and all you can do is just empathize with the family because
okay.
you really can't understand why somebody will just rush and um, basically act out of emotion and just do something as wicked as they did. And it's disheartening. I don't really have the words, but I can only
Okay.
pray and ask for God to comfort them because
For
they've
them.
been through a lot. Yeah,
Mm,
yeah,
mm, mm, mm. Right, right, right. Wow. All right. Okay. So
yes,
we've also paid our tribute to the lady Alian Andam and also to the family. Well, life must go on, isn't it?
yeah. We definitely need to obviously be our brother's keepers, as they say. We definitely have to watch over each other.
Whatever each other.
I mean, you can't have your own also attacking you on the streets. It's really sad that we have to get to this point, and for a trivial reason as this. And so I always say that we have to be our brother's keepers. When you see that somebody is going down the wrong path, you don't say, "Well, it's none of my business." Hey, let
Exactly.
them do whatever they want. Say, "Hey, I really want you to be the best that you can be. So please be careful about the things that you carry on you, or be careful
Yeah.
about the things that you're doing,
Mm,
because it's
mm,
going to end up obviously hurting you one day." And I'm sure he's regretting it at this point
yeah.
because he didn't expect to have all of this media attention. And I can imagine him thinking, well, what came over me to
So
do such a
funny.
thing? Yeah,
Yeah.
yeah.
Yeah. Yeah.
So
Mm,
if from a very young age he was really grounded, maybe he wouldn't have gone as far as he did. But
Okay.
hey,
Okay.
we can't really predict because we don't know what was going on at the time.
Mm,
So we
mm,
should all learn
mm.
to be
Exactly.
each other's keeper. Yeah, yeah.
Okay. Thank you
Yeah.
so much, Eunice, for the encouraging words. So, if you could quickly take us through today's, this week's update. Yeah.
Mm, yes. Okay.
Look at
So
how excited you are. Everybody
yes,
good news
because
for
there's
us.
a lot, there's a lot to get through in terms of the updates. So
Okay.
it's one of those months that we will say a lot has gone on, and so just to make sure that people are aware of what has gone on and what they can look forward to. And as we were mentioning, we know that the home office fees will be rising. Um, from the 4th of October, which is
Mm,
this next week coming Wednesday.
okay.
So these are for entry clearance applications, which are out of country applications, and in country applications as
Okay.
well. So you would realize that most of the fees have gone up by at least 20%. So if, for instance, you were going to pay 1,526 for an entry clearance application, now it's going to be 1,820 something for the out of country application. And let's remember, we have what we call the immigration health surcharge.
Yeah.
So, with the immigration health surcharge, you always have to know that it comes with those applications which the person is applying to come from outside the UK into the UK, um, whether it's a student visa, a skilled worker visa, a family visa, you will have to pay that immigration health surcharge unless it is an indefinite leave to remain application
Mm,
into the UK. So you don't pay an immigration health surcharge if you're coming for 6 months and less, or you are coming for that indefinite leave to enter. So for those two categories, you wouldn't have to pay that immigration health surcharge.
right.
But when it comes to the immigration health surcharge for adults, it's going to rise from 624 to £1,035 per year.
Oh,
So it's a huge jump in terms of the immigration health surcharge because they're saying they want to be able to fund the NHS and the salaries that the healthcare workers are demanding.
okay.
So if you were going to pay let's say 1,900 for immigration health surcharge for 2 years and 9 months. Now you're going to have to pay over 3,500 for that same application
Okay.
because of the increment. Um, those who are also here in the UK will have that increment also passed on to them. So, uh, for immigration health surcharge, whether you are inside the UK or outside the UK, that increment is going to be charged to you. For children, it is slightly discounted. So, for children, you have the fees being £470 per year currently. And so from the 4th of October, it will increase to £770 per year for each child. So if you are making an application and there is a child involved, that child will also be paying that immigration health surcharge as well. And then also, you can take it that when it comes to the in-country applications, they are also being increased. And so whether you are making a further leave to remain application or a skilled worker application or a health and care worker application or a student application within the UK, those fees will also be increasing, including that of nationality or those who are making nationality applications, whether it's a child registration application or an adult naturalization application.
Application.
All these
Okay.
fees are going to be increased as well. And so let's just pay heed and obviously keep that in mind, because this is something that most people who can afford will have to pay. Obviously, if you cannot afford the fees, there's still the fee waiver request that can be made.
Okay.
So, with the fee waiver request, once you have said to the Home Office, these are my bank statements, my pay slips, evidence of those in my household, and the fact that we are not able to gather the money to pay for the Home Office fees, and that's the affordability test. So
Okay.
once you are able to show them you are not able to afford the Home Office fees, then they
Mhm.
can waive the application fee and the Home Office immigration health surcharge as well. So that is also something that families who may not be able to pay can also look forward to. So, secondly, we have our should I say, government and our Home Secretary, Suella Braverman, who have also increased their changes in terms of the rules. So we all know that when it comes to immigration, the immigration rules
Mhm.
can change and do change as often as they want. So
Okay.
on the 7th of September, they increased, I mean, they changed the immigration rules, and they came up with another statement of changes. And in that, they were able to introduce this, what we know as the electronic travel authorization. So
Okay.
I'll explain a bit about that. So electronic travel authorizations are for non-visa countries, and they are a way of us, which is the UK, being able to regulate those that are coming from non-visa countries. And so
Right.
it is requested that those people who want to come into the UK, who are from non-visa countries, so they don't need a visa to come into the UK, they can just come on visit and then go back. So those people would need to complete an ETA, which is the electronic travel visa, I mean authorization, to be able to come into the UK. So
Okay.
once you've completed it, obviously they will charge you a small fee, and then you can travel into the UK. But they've also said that if you have breached any immigration rules, or you owe the NHS any amount more than £500, it might be that you will not be given an electronic travel authorization to enter into the UK.
Okay.
And currently is being given to about 6 countries, which includes Saudi Arabia, Bahrain, um, the Arab Emirates, and a few of the Asian countries. So currently, only 6 countries have the right to request for an ETA before, obviously, they can come into the UK. So this is something that they are looking to spread to the EU countries as well, because we all know that we are now not part of the European Union, and therefore most European nationals can come into the UK on visit, but they cannot come and stay and live in the UK. So they
All right.
are looking to introduce the ETA to most European countries as well.
Okay.
And then they've also introduced within the statement of changes the fact that when it comes to our Appendix EU, most people will have the right to apply for administrative review.
Mhm.
So I know that most people would know what administrative review is, but if we don't, administrative review is where you have been refused. Let's say you applied for leave to remain or pre-settled status, and because you have been refused, you believe that it was an error because maybe the evidence was not looked at properly, or they didn't look at the law properly, and therefore you are requesting that the Home Office review their decision and come up with a different decision, basically. So that's what an administrative review is. And usually you are charged a fee for the administrative review, which is about £80. But now they're saying that they no longer want to have that in place for those making EU applications. Most of the time, you will make an EU application, and by the time it has been refused, they'll tell you you have the right to appeal, and then you also have the right to request for an administrative review.
All right.
And so from the 5th of October, you will have those changes taking effect. So if you make an application for pre-settled status or for settled status and you believe that there was an error in the decision that they made, you will no longer have the right to request for administrative review, but
Okay.
instead you can apply for appeal, because obviously, due to the withdrawal agreement, all EU nationals and their family members have the right to apply to the courts for an appeal if they believe that the decision was biased and was not correct, or there was an error in one way or the other. And then another thing is the fact that when it comes to our lawful residence applications, when I say lawful residence applications, I'm talking about applications where people have lived here for a period of at least 10 years, and they are making an application based on that lawful residence. And usually it is an indefinite leave to remain application. And what they've introduced is the fact that when it comes to making those lawful residence applications, people would have included their time here on a visit visa, or their time here as a domestic worker, or their time here as a short term student. They're saying we are no longer going to look at those times when you came here as a visitor. If you came here on a short term study, we're not going to look at that. If you came here as a domestic worker, we're not going to look at that period of time that you came here as a domestic worker. So they've taken out a lot of the should I say, gray areas where people will come and stay and then switch to a different route. So I know that there will be people who may have come here on a visit visa and were able to switch to the family route and then go on to get their indefinite leave to remain. If you came here, obviously, under those routes, they're saying that will not be counted towards your lawful residence, because it was not a period where obviously they were thinking you would come and settle in the UK. So they've said clearly that those periods will not be counted towards your lawful residence. But obviously, if you've been to prison or you have been in breach of immigration rules where you did not have leave to remain, or you did not have immigration status, then of course that will also be discounted. You will not have that count towards your lawful residence here in the UK. I think the main emphasis for a lot of people was, why is it that my visit will not be counted? Because to me, I was here lawfully, so it should be counted. But they have said that those periods did not count towards settlement, so you cannot use that as a means to gain lawful residence here in the UK. So let's keep that under our wings, and then remember that obviously this is something that a lot of people will be looking forward to if they switch from that route to maybe student route or any other route. That those periods will not be counted. So let's just spread this so that people are aware that this is what is also going on as well. And then, lastly but not least, when it comes to our EU settlement scheme, I know that a lot of people would usually say that the EU nationals are always in the news, but it's not for any bad reasons. It's always because we all know that Brexit took place in 2021, and by the end of 30th of June, people knew that um, everything that was in regards to EU nationals and their family members and them being part of the EU obviously would have been disregarded, because now the UK was seen to be part of its own union, and it didn't have to rely on any laws that were obviously implemented by the EU. But they knew that they had to form an agreement and protect EU nationals and their family members who are living in the UK or were living in the UK. So, of course, they had to put certain things in place. And then last month, we were talking about the fact that even when it came to applying for settled status, if the person didn't apply in time, they are now given 2 years automatic, what do you call it, leave to remain for all those people who are getting to the point of their settled status but haven't yet reached obviously the point where they are making the application yet. So it tells you how much the UK has to be in sync with some of the EU treaties that were in place before they left. And so now, of course, they know that the settled status for most EU nationals and their family members can be made automatically by them emailing them, or with those that have up to date records of their leave to remain or residence in the UK. As soon as the 5 years continuous residence is up, they will go ahead and make that settled status application or indefinite leave to remain application when the time is up. And I know a lot of people have been receiving those emails, a lot of people have been receiving the updates just to let them know. So it only applies to those who have leave to remain or who have pre-settled status under Appendix EU. And it also goes to show how much our government is keeping to the terms that were agreed. When it comes to those who are dependents, so for instance, we have adult grandparents or adult children who are still dependent on the EU national. So we all know that if you are a dependent child over the age of 21, you have to show dependency. You have to be able to show that as a child, you're still not independent as yet, that you are still under your parents' roof. You still receive financial support from your parents. You are still receiving your essentials in terms of things that you eat and bills that need to be paid. Those are still being received by the support of your parents. And so we all know that that dependency has to be shown. There was recent case in regards to grandparents and the fact that obviously once the transition period was over, so the transition period was from January 2021 to January 2020 to December 2020. And then we had the grace period from January 2021 to June of 2021. And so within that time, if for instance you were making an application for your parent to join you, or you were making an application for your parent who is here to have leave to remain or pre-settled status, they did not have to consider dependency. So we all know that usually they would have asked or requested that you show evidence of dependency. So they would have requested that you show that that grandparent or that parent is depending on you financially and also for their essential needs. But obviously, during that time, under our Appendix EU family permit and Appendix EU, that request or that requirement of dependency was not there. So if, of course, that parent or grandparent previously showed that they were dependent on the EU national prior to the transition or the grace period ending, then they wouldn't have to now go on and show it if they were applying for their settled status or they were applying for indefinite leave to remain. So obviously, those who are parents or grandparents who would have necessarily had to show that they were still dependent on the EU national would not have to do so if they've already done so. But this does not apply to those who are now making the application for their parents or grandparents to join them in the UK. So if you are now making the application for your parent or your grandparent to join you here in the UK, they will definitely need to show dependency. This is only applicable to those who already made the application before the grace period was over and those who made the application before the transition period was over. So this is just a snippet of the changes that came into effect as a response to the statement of changes that were introduced on the 7th of September 2023. For some reason, I can't hear you.
My apologies. Yes, I was just appreciating you for a great job done giving us the updates. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors. And today's topic is, can I apply for leave to remain, having been on the 10-year route, then switching to the 5-year route? With me is lawyer Eunice Achampong. She's a solicitor and partner at BWF Solicitors. She just, gave us the updates in regard to the Home Office. So we're now quickly going to delve into, because lawyer Eunice has taken almost half an hour of our time. But the updates is very, very, very important as well. So, lawyer Eunice, yes. In regards to this topic, I would like to know who is eligible to apply for settlement on the 5-year route under Appendix FM.
Okay, so as our topic says, can I apply for indefinite route? That has been on the 10-year route and then switched onto the 5-year route. So just to make people aware what the 10-year route is and what the 5-year route is, before we look at who is eligible to apply under the 5-year route. So we all know that once you're a parent or a partner here in the UK, we call that family member application. And most people who do not have leave to remain will usually make an application under this route because it is also part of our right under the human rights. So if you are somebody who pays attention to the human rights, then under Article 8 of our European Convention on Human Rights, you have a right to private and family life. And so if you're saying that you have a family member who is a partner or you are a parent of a child who is here in the UK as settled or is British or has lived here continuously for 7 years, then the law allows you to make an application to remain here in the UK. And most of the time, most people will be making that application to say that, hey, I have a genuine relationship with this person. And this is the evidence to show that I have a genuine relationship with this person. So, under our Appendix FM, which is under our Appendix Family Member Route, you would see that most of the requirements are to do with you having that relationship with the partner who is either British or settled here in the UK, or you having that parental relationship with that child who is British or settled, or who has lived here for at least 7 years continuously. And obviously, those that are EU national children who have that pre-settled or leave to remain will fall under this as well.
Okay.
So, yes, if you're able to show that you have a relationship with either the partner or the child, that will qualify you to meet that relationship requirement. And then there is also the immigration status requirement. So you have under the immigration status requirement that you shouldn't be here for a period of at least 6 months or less regarding any visa route. So if you know you have a short-term steady visa or a private medical visa or a visitor's visa in general, you will not be eligible to apply under this route. Um, of course, if you do not have any immigration status or you are in breach of any immigration conditions
Conditions.
by living here as an overstayer, um, that will allow you to make the application, but you will have to meet exception 1A or B. And
Okay.
so most people who would be making this application, in order to meet this immigration status requirement, will have to have valid leave to remain in the UK. And then you also have the financial requirement. So if you're a parent, we call it maintenance. They
Okay.
expect that your income, deducting your council tax and your rent, the surplus that you have over should be equal to the income support rates that they give to parents and children in the UK. If you're a partner, they expect that the financial requirement has to meet the threshold of 18,600. So that means that if you are a partner and you are earning at least 18,600 gross income a year, then you can meet that financial requirement. And then it also comes with accommodation. You have to be able to show that your partner or your child has a suitable place to live and it's not overcrowded. So, of course, most people will present evidence of their tenancy agreement or some evidence to show that, hey, I have suitable accommodation that my partner can live in or my child can share with me.
Share with
If
you.
I'm living with my child, or if I'm not living with my child, they can definitely come over and have a night over. So usually, those are the main three, and then you have the English language as well. If you don't have an undergraduate degree or a master's or a PhD, then you will have to either take the IELTS or the English speaking and listening test at a level A2 or a level B1 or higher, whichever one you choose to do. So those requirements usually are what we call the eligibility requirements that need to be met in order to be put on the 5-year route.
Okay.
And so, yes, if you have immigration status, you can switch onto that route. If you don't have immigration status, you have to meet exception 1A of the immigration rules if you can't meet the immigration status requirement or the financial requirement or the English language requirement. But the mandatory requirement is the relationship. You
Okay.
have to always be able to meet the relationship requirement to be able to be put onto this route. So, exception 1 has to do with those who are on the 10-year route. So usually those that are on the 10-year route is because they are not able to meet one of these eligibility requirements.
Right.
And that
Okay.
is why they are put onto the 10-year route. And so in meeting exception 1 of the immigration rules, subsection A talks about the fact that it will be unreasonable for the British child or the settled child or the child who has lived here continuously to leave the UK. So if you are saying that this child has lived there all their lives, they haven't known any other country apart from the UK, of course, they are British and they want to be able to enjoy free education and free healthcare and everything that comes with being British. You can not expect this child who has lived here all their lives and is British to just uproot and go because obviously their parent hasn't got leave to remain in the UK. So if you're able to show that it will be unreasonable for this child to leave the UK and go to the country from where you are coming from, then of course, usually they would say that that requirement has been met.
Okay.
Also, when it comes to the subsection B of exception one, most people who are partners can say that they can meet this requirement if they can show that there will be significant obstacles to them continuing their family life outside of the UK, which is in the country of origin where the applicant is from. So if you know that there will be um, harsh obstacles to you continuing your family lives, then of course they want to know, and the threshold is quite high. So if you're not facing a terminal illness where it means that the other person is not going to get treatment or is not likely to get um, some form of care in the country that you are assumed to be from, then of course, usually they will expect that you must show some other form of obstacle that will be a hindrance to you or that person returning to your country of origin. And sometimes, of course, when it comes to countries where LGBT is not recognized, you are definitely not going to be able to uproot and go and live in that country if, I mean, somebody is applying as a gay couple and then you're telling them, well, they should go back to their country of origin when clearly the evidence shows that there is no acceptance of LGBT relationships in the country that they are from. And most Home Office guidance will have a country um, guidance. So they actually have caseworkers in each country where there are, should I say, great difficulties and risk and harm to people's lives. And there are reports done by these caseworkers, and they, of course, produce Home Office guidance for each country. And so, of course, when you go onto the Home Office .gov.uk website, you will see country guidance and what the report states about what is going on in each country and whether something would be an obstacle or a hindrance if they were to return. It's not always 100% accurate, so it's also good to do your own research as well to back it up. So if there is anything that is seen to be an obstacle, whether it's a war, whether it's to do with your right to sexual orientation, whether it's the fact that the person has a terminal illness for which there's no way they can uproot and go, or it could be that there's a risk to their lives and therefore, unfortunately, they are not able to uproot and just leave the UK. Otherwise, in most situations, for partner applications, you will have to make them out of country and show that you meet all the eligibility requirements before you can apply. And then when it comes to those obviously who would want to switch from the 10-year route to the 5-year route, I think that it is important to realize that unless you are able to meet the relationship requirement, the immigration status requirement, the financial and accommodation requirement, and the English language requirement, you will not be able to just switch from the 10-year route to the 5-year route. And I know that a lot of people usually want to switch route once they are able to um, gain all those eligibility requirements. And let's not forget that there are requirements called suitability requirements. So you have to be able to also meet the suitability requirements, which also include things like you not owing the NHS, you also not being in breach of any immigration rules, you paying litigation costs if there are any litigation costs to be paid, you not having penalties or convictions. And so if those suitability requirements are not met, then of course you may remain on the 10-year route rather than the 5-year route. So it's important that people know what requirements have to be met to switch. And so if you do switch, then yeah, that's good. Once you are able to switch, remember that you have to make the application on the 5-year route twice. So yes, you were given 2.5 on the 10-year route, and then you switch to the 5-year route. But once you've made that switch to the 5-year route, you have to complete a full 5 years. So it means you are doing 2.5 for a third time before you can obviously make an application for indefinite leave to remain. So if your first time was on a 10-year route, your second application was granted to you on the 5-year route, and then the third application was granted to you on the 5-year route again, once you've completed that 7.5-year period, you can apply for indefinite leave to remain on the 5-year route. I couldn't even hear you. I think your volume, something has gone wrong in terms of your volume. No. Um,
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
It's good to have you back.
Hello, Ines, can you hear me?
Yes, I can.
You can hear me?
Yes, yes,
Oh, my
yes.
sincere apologies. I think it was a technical hitch.
Yeah.
I had someone on the line who was waiting to speak to you.
Oh,
Yes. So I'm
okay.
going to quickly give him a call for him to, he desperately wants to, ask his questions. Ladies
Okay.
and gentlemen, my sincere apology for the technical hitch. Yes. So we have got the gentleman on the line. Hello, sir. What's your name and where are you calling from?
My name is Nasiru Abdulrahim. I'm calling from Coventry, ma'am.
You are welcome, Nasir, and thank you for your patience. Yes, Laura Eunice is here for your question.
Okay, ma'am. Thank you, Laura Eunice. Glad to be able to get in touch. Just for a quick one, I brought my brother here on the EU family, as a dependent. He came March this year, and he's given work permit. So I applied this application in 2020. So can he work? And do I still need to support him financially?
Okay, so as I was mentioning at the beginning when I was giving the updates, obviously if you are an EU national and you have a brother who was able to come as an extended family member, they would usually need to show dependency. And that dependency, obviously, they've said that it doesn't need to apply for those who are parents or grandparents, and that is family members in the direct line. So your brother is an extended family member, but he's not in the direct line. He's your extended family member because he's your brother. And so, unfortunately, he definitely still needs to show dependency on you by the time his 5 years is up. So, I know that is a bit difficult because he's an older man. They've said he can work. To tell you the truth, they put on all the all the biometric cards that everybody has the right to work. It's only when you are going to make the application that you realize that, oh, I was supposed to show dependency. Then it becomes a bit of an issue. So please, yes, he can work, but not to be able to financially be independent from you, such that he will now have to be cut off from you and then have to look to do an application on a different route altogether. So please, please, please do make sure that you are helping him financially in terms of his essentials. So if he's now schooling, then of course he can say that he's relying on you to support him financially because he still needs a place to live, he still needs clothing, food, and the rest of it. But if he's working and he's earning his own money, then it's obvious that he's not dependent on you. And therefore, when it comes to applying for settled status, it might be difficult for him.
Okay. Thank you very much.
You're
Thank
welcome.
you for that.
All right. Take care.
Thank you.
All right.
Appreciate it. Thank you.
Bye.
Yeah.
Bye. Yes. Yes. So, Lawyer Eunice.
Sorry about that.
It's okay. It's okay. That's one of those things. I think our
Yeah.
time is fast spent. So I think you were just concluding
Yeah.
on your point.
Yes. So I was just saying that when it comes to those who have applied onto the 5 year route, it will be a continuous 2.5 years and then another 2.5 on the 5 year route to make an application for indefinite leave to remain. But those who are on the 10 year route will definitely have to complete 2.5 years 4 times on the 10 year route to be able to apply for indefinite leave to remain. And so obviously we need to bear that in mind as well.
Okay. All right. I've got Amina sending us a question. She says, please, I've previously completed and passed the SO at the level B1. When I put in my last leave to remain application, yes. She wants to know if she needs to do it again, and will she need to pass the life in the UK test before submitting the indefinite leave to remain application. She's asking because her leave will be expiring in a week's time.
Yes. So, a lot of people say, isn't the life in the UK test only for those who want to naturalize as British? And I now have to say to them, unfortunately, it's now come under our immigration rules, and even those who are applying for indefinite on the parent route or partner route still have to complete the life in the UK test and the English language test to be
Right.
able to apply for indefinite leave to remain. And so she said she's done the English language test before. If she
Mm,
did it at a level B1 and it was previously recognized for a successful application, and she said she used it for her last leave to remain. So obviously she was successful in her application. So yes, she can use it again for her indefinite leave to remain application. So, yes, she can go ahead and use the same B1 test for the indefinite leave to remain application. And then she will have to complete their life in the UK. I know she says she has a week.
a
Uh,
week.
if she's not able to take the life in the UK test within that week, unfortunately, it will be difficult to complete the application because you will have to show that you have completed the life in the UK test and then put your reference number in order to
Mm,
even move on.
right.
So if you haven't got the life in the UK test results, then it means you are having to make a leave to remain application again. And then once you are able to pass the life in the UK test, then you can apply
Mm,
for
mm,
indefinite leave.
mm,
Yeah.
mm. Good, good. Yes, let me quickly go to the next question. What happens if I'm not able to show I still have direct contact with my British child on which my leave to remain was granted? Will my application for indefinitely be refused, or further leave to remain be granted to me if I don't satisfy all requirements? Lawyer Eunice.
That's a very tricky one. So you are a parent, you have to be able to show that you meet the relationship requirement. So if you are saying that for any reason you are not able to show that you are still in that subsisting relationship with the child, um, you will not be able to complete the application under the parent settlement route, but we also have the lawful residence route under 276B of the immigration rules.
Okay.
So maybe instead of doing it under the parent route, maybe it will be advisable to go onto the lawful residence route where you can show that you have lawful residence for 10 years. And if you are able to show that you have lawful residence for 10 years, then you
Okay.
can go ahead and make the application for indefinite leave to remain
To remain.
under 276B instead of the parent settlement route. And I think that should be okay in terms of that particular application. Yeah.
Okay. Yes. Thank you so much, Laura Eunice, for that assurance. I think when you said it's a tricky one, I was like, oh
Yeah.
no.
Because it's a requirement that has to be met. Yeah. Yeah.
Yeah, yeah. So, Laura Eunice, time is fast spent. Could you please give us just a brief for the
Yes.
benefit of those who have just joined us towards the end of this show? Just give them a brief, and also very, very important, your details for them to, book an appointment to come and see you for further advice and support.
Okay, so we've been talking about applications for indefinite leave to remain, either under the 10-year route or the 5-year route. If you have any questions other than immigration, so we do not just deal with immigration law, we also deal with family law, whether it's to do with child arrangement orders, whether it's to do with you going through an abusive relationship and you wanting the court to grant a non-molestation order or an occupation order. We can assist you in all those areas. If you are looking for support, even in terms of housing and any sort of social issues that you may have, we also deal with that. And we also now deal with probate and wills as well. And so if you have any assets, it doesn't have to be just property. If you have any assets, whether it's shares, investment accounts, and you feel that, hey, I want these properties or assets to be given to family members of mine that I cherish, please, we also deal with services in those areas as well. You do not have to be old and dying to make a will. I always say that we always have this perception in mind that we have to be old or frail or very sick to be able to make a will, but that doesn't have to be the mindset. If you have something, you never know when your time will come. So you put things in place and you put things in order prior to that happening. So our office number is 0208 493 7340. So if you want to call us and obviously book a consultation, or you want to come and see us, once you call the office number, from Monday to Friday we are opened, and we open from 9:30 a.m. to 6 p.m. So from 9:30 a.m. to 6 p.m. we're opened. And if you want to come in to see us, we are situated in London Seven Sisters. So we're on the fourth floor of Anna House, and it's 214 to 218 of the Tottenham High Road. The postcode is N154NP. So N154NP. And if you feel that there are questions on your mind and you really want somebody to speak to, and if we can support you, we go ahead and do that. My number, which is an out of office hour number, is 075 35 81 3910. So 075 35 81 3910. So if, of course, you want to give a quick call just to have your issue addressed before you come and see us, you can do so as well.
Thank you, Lawyer Eunice. I also like to take this opportunity to thank you, our viewers, for making this show what it is. So we thank you so much. I believe that this has impacted you. I mean, you've learned so much from today's topic, and please make sure you share to your loved ones and your contacts so that they will also benefit from this program. Thank you so much. And I believe we'll come your way again another time with another interesting topic. Until then, take good care of yourself and stay safe. Thank you.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208-493-7340 or 077-127-61884. BWF Solicitors, your trusted legal partner.